Now, I would like to extend my heartiest and warm welcome to our chief guest, Honorable Mr. Justice Surinder Gupta, former Judge, Punjab and Haryana High Court. Sir has completed his education at Firozpur and LLB from Garhwal University, Srinagar. After a brief spell of practice as an advocate, he joined Punjab Civil Services on 17th October and was promoted as member of Superior Judicial Services, Punjab in the year 1999. In his capacity as additional district and session judge, he remained posted at Jalandhar, Patiala, and also worked as preceding officer, Industrial Tribunal and Labour Court, Union Territory, Chandigarh. He became district and session judge in March 2008 and worked in various capacities as district and session judge cum registrar, Punjab and Haryana High Court, legal remembrance cum law secretary, Government of India, and registrar general of Punjab and Haryana High Court. He sworn as an additional judge of Punjab and Haryana High Court on June 20, 2013. Now, I would like to request our chief guest, Honorable Mr. Justice Surinder Gupta, to please share his wisdom with us. Sir, please.
Thank you, Parulji. Am I audible?
Perfectly, sir.
Respected Madam Usha Tandon, Pradeep Rai ji, Senior Advocate and Vice President, Supreme Court of India, Shri SP Bansal, Professor Dharmender, Dean, JEL, Nishant and Ankush Bansal, Chairman, Gita Group of Institutes, all the participants, good morning to all of you. First of all, I congratulate GAL for organizing this Justice Dipak Misra National Moot Court Competition 2022. I feel myself lucky to be a part of this program in 2020, when I was there as judge also. And I have seen the level of this moot court competition, the dynamism, intelligence, and skill of the participants, the atmosphere in GAL, as Shri Bansaji was saying, that they don't only teach, they also prepare good human beings there. So it was a very nice experience in 2020. I am grateful to the management for inviting me to this program. As and when joining, I can take the opportunity to join any moot court, get experience. Pradeep ji was telling it that he did law about two decades earlier or 2 decades earlier. I completed my law in 1980. Thereafter, practiced for some time. So the concept of was not. Our request to our faculty used to be to take us to some courts and give us an opportunity to see the court proceeding. Madam Usha is also aware of it. She might have faced the same thing. I got the opportunity to attend the first moot court about, I think, 15 years back. Around 15 years, there was a moot court in a law college in Punjab, and I was invited there. It was at that time I tried to know about the moot court. While searching, I came to know about the Inns Court, England, then adoption of their curriculum by Harvard University. So I thought the law education has come to India during British time, but introduced this moot court and other things which were prevalent in England. So ultimately, I found that they have not taken the law seriously because they wanted that lawyers should come from England, judges should come from England. And you see most of the judges in the various high courts, they were Britishers. It was the Bar Council of India which organized first moot court, if I am correct, in 1981. And by 85, it became the part of the legal curriculum. The moot court is really very, very important. It polishes the skill of the student, their art of writing, research skill, networking skill, and most importantly, their practical knowledge. When a student gets an opportunity to argue before a court, maybe a dummy court, but the judges there are more serious than the judges in the courts, because in court we take care of the junior, but they are in the moot court, they are drilled like anything. So there they gain confidence and get better in articulating their arguments. I was also going through the preposition of this moot court competition, which is a very and challenging preposition. Usually in moot court, the students, the participants, they are confronted with such type of prepositions, which has very few legal precedents. This encourages them to research, create to find out the point in controversy, solutions, and try to understand the points in their favor and also in favor of the other party. They have not to prepare their case. They have to prepare the answer of the other party, which they have to put forth. Besides doing this, they have to prepare them with the queries that will come from the court. And as Mr. Pradeep was pointing out, and very rightly, that the most important thing is the solution. What solution you have for every query, every point. So that is more important. And when a participant is arguing, as Usha ji was pointing out, he has to argue to not only to satisfy himself, not only to satisfy the listener sitting on the backside, not only to convince the party, but to convince the judges on the dais. If his point travels there, he is successful. For that, he requires proper arguments, proof, quoting of long point. And the most important of all is to keep his voice humble. While doing all these things, he has to follow the mooting protocol, culture, and manners also. So there are very lot of limitations. when I was hearing and he was emphasizing that solution is the most important. An incident in my court. Though there are so many incidents, but one incident in my court which took 2 decades or more than 2 decades. I joined in 1983. Back that stuck to my mind. A case been filed by a plot owner against his neighbor. The point was very simple. Neighbor had constructed a wall in his plot adjoining the plot of the plaintiff and has kept so many openings, apertures in that. The plaintiff wanted that this is the violation of his right of privacy and he cannot do so. The relief he was seeking was that he should be directed and the relief of mandatory injunction should be given for those apertures, those openings. In routine, notice was given to the counsel for defense, to the other party. Counsel for defendant appeared. The counsel for plaintiff was that he cannot, the defendant cannot keep any opening towards my plot. He is invading the right of privacy. And it appeared to be very logical. But the counsel for the defendant was raising the wall is in my plot. It is in the plot of the plaintiff. I can keep any opening, any window, any aperture. How can he stop me? So, as you know that every case takes its time. We take the written statement, replication, frame the issue, evidence and everything. I saw that a young lawyer who was associated with the learned senior counsel for plaintiff, he was whispering something in his ear. The counsel for the plaintiff took the adjournment and I asked the defendant to come up with the written statement. On the next date, the counsel for the defendant did not file the written statement, sought adjournment. The counsel for the plaintiff made a statement that, sir, record my statement, I am withdrawing my suit. Why? Have the matter been amicably settled? No, sir. He just pointed out to young associate and told me that he had caught the argument of the learned counsel for the defendant and found the solution. Outside, he had advised the plaintiff that he has raised the wall in his plot. You raise the wall in your plot, closing all his opening and apertures. And my client followed his advice. He has raised the wall and all the openings in his wall have been closed. So this was the solution. This is what the moot court helps in shaping the mind of the participants. What is required? Only the young are just the argument of the defendant is at liberty to raise ball in his plot and keep any opening. All right. Similar liberty is available with the plaintiff. At times there are no moot court, but the moot court at present high. No doubt. Case would have continued for a long time and plaintiff may have got the relief, but it would have taken time, but with immediate. So, moot court garnering the skill of the participant, allow them to understand the real issue and come up with the instant solution. This goes a long way and help the lawyers as an advocate in corporate elsewhere. This moot petition not only polished of presentation of facts, the point, but develop in them the art of listening the other party. Lawyers are very difficult listeners. They can argue long for, but it's difficult for them to listen. The Moot court develops the art of listening. When you are listening and listening very carefully, you learn a lot. You get clarification on various points. Remove many ambiguities in your mind and come out with very clear and emphatic opinion about a particular problem confronting you. So GIL has been giving opportunities to the participants, and it's very funny to notice that this Moot court is going on for the last 12 years. And despite all these difficulties and present pandemic condition, they have taken the courage to connect. I again congratulate them. And I convey my good wishes to all the participants. They will get great experience and a lot through this motivation. It's winning is not material. It's the courage to participate is material. Again, thank you very much.
Thank you so much, sir. And I will take a minute to appreciate the fact that such interested students with you, sir, and understanding the nuances of legal fraternity and hearing it from you, sir, surely means a lot and will leave an impact of them forever. Thank you. Heartfelt thanks to you, sir, for enlightening us. And indeed, we are delighted to have you with us. Thank you so much.